Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Hello everyone and welcome back to another live stream with me, Grizzly. This is Grizzly True Crime and we are here for jury instructions, yes, in the case against Nicholas Kassotis, which has been wild. It's been very interesting. If you missed day 7 of the trial, oh man, you got to go watch it. All the timestamps are there for you. Not only did Nicholas Kassotis take the stand and tell all those stories all over again about Jim McIntyre and the velvet bag with the fake ashes and all that, but there was also closing arguments, and the defense went first, and then the state, and it was very powerful. So I hope you'll go check it out if you missed it. Welcome everyone. Let's put on the court feed, shall we? Because it's going to be about half an hour of jury instructions. So let's discuss our plan for the day if you're watching live with me. We'll watch the jury instructions together. We'll say bye, and then we're going to teleport to the verdict watch stream. And there, if there's any questions from the jury, I will type it in chat. Lots of people also type it in chat. Sometimes the mods do, sometimes I do, sometimes people do, right? I'm monitoring all the time. And then when a verdict is reached, we will go live. And that's great as well. Then you'll get the notification. You won't miss it. You know what I mean? Okay, so what I'm going to do is, okay, we've got that. Let's put the sound on. Just see. Wait, we want to catch it exactly when the sound came on, which is here. Here we go.
Gone over State's Exhibit 1.101, the USB that the state has used during the course of these proceedings. Located on this are the electronic data that could not have otherwise been given in a physical form. There are also exhibits on here that I have articulated throughout the course of the trial, including the exhibits I used to refresh recollection, search warrants, things of that nature. Counsel and I have reviewed it. There is nothing on this USB other than what was used during trial. Counsel, do you agree to that?
That's correct, Your Honor.
Right. We've also gone through all of the physical evidence, Your Honor, meaning the exhibits and the documents. There are 4 exhibits that have been removed. They are 1.109, 1.111, 1.110, and 1.117 because they were demonstrative only. Okay. I have talked to counsel about the evidence in terms of the forensic crime laboratory reports, as those could be considered continuing witness. Counsel and his client have communicated. They have determined that it is in their best interest to submit those to the jury and that they do not wish to have them extracted. They wish them to go back.
State agrees?
I don't have an objection, Judge. They're welcome to go back to the jury. Okay. That would include the autopsy, all the reports from the DNA analysts. That would include the reports from the toolmark expert, as well as the other experts in this case, toxicology and so on. And counsel, is that correct?
That is correct.
And that was after talking to your client as well?
That is correct.
All right, very well, then those exhibits will go out to the jury.
Thank you, Your Honor.
The only question we had somewhat, Judge, was physical evidence. There are things like bloodstain cards, things of that nature. Counsel and I have talked about it, the totes themselves. Those things were touched by the crime laboratory and obviously are still potentially not something that they should potentially get without maybe some interaction with the court. So we're going to ask that all of the documentary and physical, like photographs, things of that nature, can go back with them. I don't have an objection or need a note for that. But if they wanted to, for example, see the knives or to see the totes or something of that nature, that they would just need to send a note to the court and ask to see them. Is that correct, counsel?
Yeah, we're in agreement on that, Your Honor.
All right. Thank you.
Thank you.
Thank you.
All right, anything else before we bring the jury in?
No, Your Honor.
Nothing from the state.
All right, let's bring our jury in.
Okay, excuse the noise of my air conditioner. It's extremely hot in Switzerland today, which is August 14th of 2025. Maybe you're watching from the future. If you're watching live with me, firstly, thank you, Becky P, for your
Please
sticker.
turn the phones off or have them on silent.
Okay, let's wait. I put a poll up in this live stream saying, how long do you think the jury will deliberate? 39% so far have voted 1 to 2 hours. 43% said 2 to 4 hours. 15% said 4 to 8 hours. and 2% said 8+ hours or a hung jury. We're going to go over the counts again after this, and I might even read you his short story. You could feel the tension in the room. Jury's coming back in. Jury instructions before they deliberate.
I'm going to have the court reporter hand you the verdict form that we've put together in this case, just to have a look. Here's one for the state. Yes, sir.
Thank you so much, brown-eyed gal.
All right, everyone, please be seated. Good morning, ladies and gentlemen of the jury. Good morning. And I'm required one last time to ask if you were able to abide by the court's previous instructions regarding access to media. Did we have any problems? No. All right, then I will now read you the law that applies in this case. Ladies and gentlemen of the jury, you are considering the case of the state of Georgia versus Nicholas James Kassotis. And this is Bill of Indictment number 2024 R67 in the Superior Court of Liberty County, Georgia, the February term of court 2024. And the grand jury has indicted the defendant with the following offenses: Count 1, malice murder; Count 2, felony murder; Count 3, aggravated assault; Count 4, concealing the death of another; Count 5, possession of a knife during the commission of a felony; Count 6, possession of tools for the commission of a crime; Count 7, possession of tools for the commission of a crime; Count 8, possession of tools for the commission of a crime; Count 9, possession of tools for the commission of a crime; Count 10, possession of tools for the commission of a crime; Count 11, removal of body parts from scene of death; and Count 12, tampering with evidence. Now, you will recall at the beginning of this trial, in fact, in jury selection, the entire indictment was read to you. I'm not going to do that again, but I want to remind you that your oath requires that as you deliberate and go through each count, that you read the entire language that's inserted in each of those counts. So, ladies and gentlemen, the defendant has entered his plea of not guilty to this indictment, and the indictment and the plea forms the issue that you have to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with the presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is the doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. I charge you that facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raises a speculation or conjecture of the defendant's guilt, is not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to the case and instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law given in this charge to the facts as you find them to be. Your oath requires that you will decide this case based solely on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses, any exhibits admitted during the course of the trial. Evidence does not include the indictment, the plea of not guilty, and the opening or closing statements made by the attorneys or questions asked by the attorneys. Evidence may be either direct or circumstantial, or it can be both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witnesses' manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average person. The law permits expert witnesses to give their opinions based upon their experience and training. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all other witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of the same witness that was made before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pre-trial statements and testimony when compared to the same witness's testimony at trial. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe and what testimony you may not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. I charge you that a statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. To be voluntary, a statement must be freely and willingly given without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you must also consider to what extent the defendant was informed of his rights, as discussed below. The burden of proof is upon the state to establish that the statement was voluntary. That is, it was freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of his constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. Number one, the defendant has the right to remain silent. Number two, if the defendant chooses not to remain silent, anything he says could be used as evidence against the defendant in court. Number three, the defendant had a right to consult a lawyer before any questioning and to have the lawyer present with him at all times during any questioning. And number four, if the defendant did not have money for a lawyer, that a lawyer would have been provided for him to represent him before any questioning and to be present with him during questioning. The burden of proof is upon the state to establish that the constitutional warnings were mentioned and that they were understood and knowingly given up by the defendant. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of the witness and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find that the defendant was properly informed of these rights and that he understood and gave up those rights, then you would disregard the statement entirely and give it no consideration in reaching your verdict. Ladies and gentlemen, evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparisons is dependent upon many factors. Among the factors are the credibility and accuracy of the witnesses who were involved in the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparisons in your decision in this case. The defendant is charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of act and intention. Intent is an essential element of any crime and must be proven by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but it simply means the intention to commit the act that is prohibited by law. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make such an inference or inferences is a matter solely within the discretion of the jury. I charge you that a jury is not authorized to find a person who was merely present at the scene of the crime at the time of its perpetration guilty of consenting in and concurring in the commission of the crime unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. Members of the jury, the law of our state sets a time limit upon the state in starting prosecution in most criminal offenses. The accused is on trial for the offense of malice murder and felony murder, and under Georgia law, prosecution for these offenses may be commenced at any time. The exact date on which the murder took place is not a material element of the crime of malice murder or felony murder because there is no statute of limitation for those offenses. Prosecution for all other felony offenses included in this indictment must begin within 4 years after the offense has been committed. Prosecution for any misdemeanors included in this indictment must begin within 2 years after the offense has been committed. If you find from the evidence that the indictment in this case was not filed within the required number of years after the offense was committed, it would be your duty to acquit the defendant. Now, ladies and gentlemen, the law provides that criminal actions shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proven in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Liberty County, is a jurisdictional fact and must be proved by the state beyond a reasonable doubt as to each crime alleged in this indictment. Venue must be proven by direct or circumstantial evidence or both. Criminal homicide shall be considered as having been committed in the county in which the cause of death was inflicted. If it cannot be determined in which county the cause of death was inflicted, venue is proper and may be proved in the county in which the death occurred. If a dead body is discovered in this state and cannot be readily determined in what county the cause of death was inflicted, venue is proper and may be proved in the county in which the dead body was discovered.
I'm really glad that the state clarified that twice in the beginning and end of their closing arguments. District Attorney Laurie Bale, that if the jury, no one knows exactly where Mindi was murdered, although they speculate at the house based on the blood and the missing rug, right, or the replaced rug. But that was important to say, well, okay, if you can't prove that, then the next, I'm not speaking good legalese right now. The next important point is where the body was found, and that can help them then prove the malice murder and the felony murder.
Ladies and gentlemen, I will now charge you on the offenses that are alleged in this bill of indictment. Count 1 alleges malice murder. For malice murder, the state must prove the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Ladies and gentlemen, count 2, the defendant.
Okay, so there's going to be 12 counts, right? So count 1, malice murder. I mean, to me, check, guilty, very, very guilty. They have to show that he caused the death unlawfully and with malice aforethought, with malice, unlawful intent to kill. With deliberate intention, they don't have to prove premeditation, and I think there's plenty premeditation proven by the state in this case, in my opinion. Abandoned and malignant heart. I mean, every point that the judge just raised, to me, I could think of many things that Nicholas Kassotis did that like, oh, okay, even if you say abandoned and malignant heart, this whole story of after Mindi was murdered and dismembered, oh, she was just in the hospital, I don't know, I was talking to her through the Signal app, didn't visit, didn't call, tried to call, there was no signal. All of that, you thought she was pregnant, wife is in a birthing center that he made up, right? All these stories he made up, and you don't go visit, and then they tell you, oh, sorry, she died, and he's like, okay, all of that, everything, let alone, I mean, we can look at the other evidence, like he bought a shovel, he bought a deer processing kit the day before, he went out there where his car was spotted, where the knife was found, he bought a knife as well. All of that, the totes were out there. I mean, to me, okay, check. If I was on the jury, oh my, yeah, count one, guilty.
Is charged with felony murder. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault is a felony, which I will define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. I will now charge you on the elements of aggravated assault. For aggravated assault, the state must prove the defendant assaulted another person with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. An offensive weapon is an object that is likely to cause or actually does cause death or serious bodily injury if used against another person. The presence of an offensive weapon or the appearance of such may be established by circumstantial evidence. The state is not required to admit into evidence the offensive weapon used by the defendant in order for the defendant to be found guilty of the offenses of malice murder, felony murder, or aggravated assault. I will now charge you, ladies and gentlemen.
Okay, pause. So count one, it was malice murder. Count two, felony murder. And count three, aggravated assault. I mean, if you missed any of the testimony, it's there for you. It's all time-stamped for you. Everything, there's no breaks or anything like that. So I hope you'll go check out some of the testimony. But just to remind you that Mindi Kassotis' body was dismembered, found in 4 different locations over a 3-mile radius at the Portal Hunting Club, about an hour south of where they were living. And at the place where they were living, an Airbnb, her blood was found on a futon. There was also blood on the floor, and they didn't say that was her blood. I think they said they didn't test that. But there was also blood spatter on the wall. And the rug that had previously been there had been replaced. And Nicholas Kassotis' reason is because the dog got sick on the rug. That's his reason. So where is the previous rug? Oh no, they threw it out. Mindi put it in a plastic bag and then it just smelled bad, so they threw it out. That's his reasoning. But if they also spoke about her injuries based on the autopsy, which, can you imagine how horrifying that is, because she was in 4 different pieces, right? Torso, leg, and a buried head. She had blunt force trauma to her head, 9 blunt force injuries to her head. 1 fractured her skull. she had 3 abdominal injuries, which the state said in their closing arguments they believed that Nicholas Kassotis believed that Mindi was pregnant and that he was really angry that she wasn't. And that was interesting as well, because they told us in opening statements, we will tell you why she had abdominal injuries. You know, so yeah, there was that as well. She also had defensive wounds. She had bruises on her arms and all of that. So to me, that sounds like the state has proven malice murder, felony murder, and aggravated assault, right? Based on the judge's conditions laid out there. But I mean, we'll have to see what the jury decides. We're just talking it out now based on what we've seen, right?
On possession of a knife during the commission of a felony. For possession of a knife during the commission of a felony, the state must prove that the defendant had a knife with a blade at least 3 inches long on his person while committing a felony, which is one of the following: a crime involving another person, concealing death of another, which is a felony, which I will define for you shortly. And I will now define for you the elements of possession of tools for the commission of a crime. For possession of tools for the commission of a crime, the state must prove the defendant possessed a tool or device commonly used to commit the crimes alleged in the indictment and intended to use the tool or other device to commit a crime. With regard to the charge of possession of a knife during the commission of a felony or possession of tools for the commission of a crime, the state must prove that the defendant possessed the knives or other devices at issue in this case. Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the knife, tool, or device. Constructive possession means that all times of the alleged offense, the defendant may not have had direct physical control over those knives or devices, but that he did knowingly have both the ability and the intention to exercise control over those objects. Now, ladies and gentlemen, in count 4, the defendant is charged with concealing the death of another. I charged you that the state must prove that the defendant concealed the death of another person, which hindered the discovery of whether that person was unlawfully killed. In count 11 of the indictment, the defendant is charged with removal of body parts from the scene of death. And I charge you that it shall be unlawful for any person to remove from the scene of the death or dismemberment of any person or any human body part thereof. Now, with regard to count 12, where the defendant is charged with tampering with evidence, I charge you that a person commits the offense of tampering with evidence when, with the intent to prevent the apprehension or cause the wrongful apprehension of any person or to obstruct the prosecution or defense of any person, he knowingly destroys, alters, conceals, or disguises physical evidence or makes, devises, prepares, or plants false evidence. Now, ladies and gentlemen, after considering the testimony and evidence presented to you, together with the charge of the court, if you should find and believe beyond a reasonable doubt that the defendant in Liberty County, Georgia, did commit the offenses as alleged in the indictment, you would be authorized to find the defendant guilty of that offense, and in that event, the form of your verdict would be, we, the jury, find the defendant guilty. However, if...
But is it guilty AF though, Judge? We find him very, 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 very guilty. My goodness. So, I mean, the possession of a knife during the commission of a felony. Yeah, check. We know that he bought that knife at Home Depot. We also know on November 28th of 2022, the day before he went out to the area where Mindi's remains were found, he bought a deer processing kit, which he just says, whoops, left at the Airbnb, even though he pretends that Mindi told him from the birthing center to buy it for her brother for Christmas. Yeah, he was Christmas shopping. This guy, I know some people Christmas shop a month in advance. This guy, I don't think so. I don't think he shops for anyone but himself either way. But we know there was the deer processing kit. We see him in the Home Depot evidence with that insulation knife. That knife was found at the scene where Mindy's remains were found, where the totes were found, and it had cleaning wipes on the handle. Now he claims that's not his knife. He's never seen that knife until it was introduced into evidence. So they say, where's the one you bought? Well, that one was either in my vehicle, or Mindy's dad had it, or, you know, he left it at the Airbnb. Oh, please. It's there. It's right there. And I think it was probably a decoy. You know what I mean? Like, ooh, look at this knife here. Or the state says they think that he cut Mindy's flesh with it. Ooh, my goodness. They think that he dismembered Mindy there. I mean, that is a scary thought too, because it's broad daylight. He went out there for 2 hours at around noonish. What? Out there to the Portal Hunting Club? That is scary. So I think the possession of a knife during the commission of a felony, sorry, didn't finish the whole word. That I think the state has proven as well. The possession of tools for the commission of a crime, I know yesterday, with outside the presence of the jury, the judge said, count 7 to 12 is all a repeat of that, the possession of tools for commission of a crime. He said he's going to give it to the jury, but that one's a little tricky. So, there's so much evidence against this guy, right? Okay, so let's continue.
If you do not believe the defendant is guilty of an offense alleged in the indictment, or you have any reasonable doubt as to the defendant's guilt of that offense, then it would be your duty to acquit the defendant of that offense, in which event the form of your verdict would be, we the jury find the defendant not guilty. By no ruling or comment that the court has made during the progress of this trial have I intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the accused defendant. Your verdict should be a true verdict, based upon your opinion of the evidence, according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts of this case objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice for or against either party. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourselves with punishment, and you are prohibited from discussing any potential sentences in this case. One of your first duties in the jury room will be to select one of your members to serve as the foreperson. He or she will preside over the deliberations, and he or she will sign the verdict, to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's point of view. Each of you must decide this case for yourself, but you should do so only after a full discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors. You are not permitted to conduct any research. You are not allowed to consult any other materials. And I don't believe that you'll have your phone, so I don't think that's an issue. So whatever your verdict is, ladies and gentlemen, it must be unanimous. The verdict must be in writing and signed by your foreperson, dated and returned to be published in open court. Now, ladies and gentlemen, we have prepared a verdict form that you'll be able to use. You will also have the indictment that fully sets forth all 12 counts. So as you go through the body of the indictment, you can read count 1. You can read through the entire language that is set forth in the indictment, and then you'll see that the verdict form says, we, the jury, in the above title action find the defendant, count 1, malice murder. And there's a block that you can check not guilty or guilty. And it's the same for all 12 counts. So after you have reached a unanimous verdict, and it has been signed and dated on the back page by your foreperson, you would then simply knock on the door, tell the bailiff that you have reached a verdict, although you would not disclose what that verdict is. Then we would bring you back into open court where your verdict will be published according to law. Now, there are going to be a lot of exhibits that will go out with you. These large boxes, the large boxes of physical evidence, we're not going to send those out with you at this time. But if you feel that you need to observe or look at those objects, if you would just simply write a note to the bailiff, and we'll be happy to bring you back out so you can take a look at the object that you wish to see. So I'm going to allow you to go back to the jury room at this time, but you will not begin your discussions and deliberations until you receive the indictment, the verdict form, and all of the physical evidence that will be sent with you. So you are excused at this time.
I'm going to show you the indictment, and we're going to read his short story that he allegedly got paid $300,000 for, which makes very little sense to me. But there are articles, you know, saying Sony Pictures preemptively acquired film rights to, I think my mother-in-law is trying to kill me. So we'll read that and the indictment. Hang in there. Then we'll teleport to the verdict
Everyone,
watch.
please be seated. Let the record reflect the jury's now out. Ms. Bayo, on behalf of the state, are there any objections to the charge of court?
There are no objections to the charge or to the verdict form, Your Honor.
Mr. Weinstein.
The defense also has no objections to the charge or the verdict form.
All right, thank you. So we've already reviewed all the exhibits. They're in proper order. I assume we can go ahead and have them sent out to the jury.
I don't dispute that, Judge. I know normally it's the court's practice to have two separate rooms for alternates to not be with the jury. I know we didn't put it on the record. I just want to make sure that that's very clear.
It is, and I've got their names. Let me get the bailiff.
Oh, nice. Verdict clock. So where are they now? Let's go.
Mr. Weinstein?
We're about 10 minutes behind the clock. So they must have started around 9:35 Eastern. Okay, yeah, don't say their names.
Okay. The 4 alternate jurors.
Yeah. No sound.
All right, then we'll be in recess until we have a verdict.
Thank you, sir.
Nicholas Kassotis does look defeated today.
Ms. Bayo,
Yes, sir.
if you and Mr. Weinstein, this doesn't.
Okay. Stand by, everybody. We're not teleporting yet. We're going to look at the indictment. We're going to look at a little article. We're going to read his little short story. Thankfully, because it's quite short. Allegedly, his short story. I've had probably 50 emails sending it to me. So thank you so much, everyone who sent it to me from Reddit. And we shall read through that quickly as well. Everyone keeps asking who this lady is. I don't know how you think I'm going to know or anyone's going to know. We don't know. And it's better not to guess, right? Okay, so let's just go forward here. So they've been deliberating for 11 minutes or so. And the time now, 9:47. So around 10:36 Eastern. I'm going to, 9:35 Eastern or so. The jury left the room. Will they be back before lunch or what? Okay, so what we're going to do now is, let's go like this. Yes, bring up this. Okay, here we go. Let's quickly look at this indictment, and then we'll look at the short story. Okay, and take this. Okay, so you can see that nicely or no? Let me make it bigger for you. Okay. So, just so that I don't know about you, I like to see them like this. You know, or the whole list. Let's see the whole list of them and then I can remember it better. So count 1, malice murder. Count 2, felony murder. Count 3, aggravated assault. Count 4, concealing the death of another. Count 5, possession of a knife during commission of a felony. If I was on the jury, I'd already tick guilty, 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 guilty for count 5. Okay, count 6, possession of tools for the commission of a crime. Yeah. Okay, possession of tools for the count 7. So count 6, 7, 8, and 9, and 10 are possession of tools for the commission of a crime. And count 11 is removal of body parts from the scene of death. Yeah, guilty. And count 12, tampering with evidence. I think so. I think the possession, this many counts of possession of tools for the commission of crime will take the longest to deliberate on, because they'll have to look at the language of all of that, right? Of each one. But I mean, you just never know what the jury's going to do, right? You just never know. Now, count 1, it says again here, in the name and behalf of the citizens of Georgia, and charge and accuse Nicholas James Kassotis, aka Nicholas Stark, with the offense of malice murder, a felony for that the said Nicholas James Kassotis, aka Nicholas Stark. I love that. I actually love that the jury sees this indictment, even though the judge said it was the indictment, the opening and closing, okay, the indictment, the not guilty plea, the opening statements, the closing arguments, and any questions asked by the attorneys, that's not evidence. But they do have this. And just to remind them, look, remember when he left after Mindi passed away, was murdered and dismembered, and then he just left and changed his name? Yeah, that's all already just here in the indictment. You just see it it's in your face as you look at this. So yeah, Nicholas Stark in the County of Liberty in the state of Georgia between the 21st day of November 2022 and the 29th day of November 2022, the exact date of the offense being unknown to the grand jury, which later the medical examiner clarified that Mindi was murdered between November 27th and 29th of 2022. And his car was out in that area, and he places himself in that area, the hunting area where Mindi's remains were found, on November 29th of 2022. So he was a very busy boy between the 27th and 29th, because not only is he accused of committing murder in that time, but also of going to buy a deer processing kit, then buying a knife from Home Depot, then going out to the Portal Hunting Club where his car was spotted, where the knife that he bought was found, cleaning wipes were found, and his second wife's dismembered remains. Then he had his car washed the next day. All of that. Then he packed up his in-laws and said, I'm going to move you in somewhere else, and I'm going to go now because I found my real family, my biological family. Yeah, I was stolen as a child, so I'm off to do that. Was he doing that? No. He went to go and marry another lady with a new name. Shame. Okay, so that is count 1. The exact date of the offense unknown to the grand jury did unlawfully, with malice aforethought, cause the death of Mindi Mebane Kassotis, a human being, by multiple traumatic injuries to the body, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 2, I'll read through these. I was thinking, should I read through all of these? Let's read them, because those possession of tools counts are like, those are so similar, right? So count 2, and the jurors aforesaid in the name and behalf of the citizens of Georgia further charge and accuse Nicholas James Kassotis, aka Nicholas Stark, with the offense of felony murder. And then there's the code there, a felony, for that the said accused in the County of Liberty in the state of Georgia between the 21st and 29th of November of 2022, the exact date of the offense being unknown to the grand jury, did commit the offense of murder when the accused caused the death of Mindi Mebane Kassotis, a human being, irrespective of malice, while in the commission of a felony, aggravated assault, by causing multiple traumatic injuries to the body with an unknown object, which when used offensively against a person is likely to or actually does result in serious bodily injury in violation of that code, contrary to the laws of said state, the good order, peace, and dignity thereof. 9 blunt force trauma injuries, 1 skull fracture, defensive wounds, 3 abdominal injuries, which could be stabbing. Count 3. This one is accused Nicholas James Kassotis, aka Nicholas Stark, with the offense of aggravated assault, a felony, for that the said accused in the County of Liberty and the state of Georgia between the 21st and 29th of November of 2022, the exact date not being known, did make an assault upon the person of Mindi Mebane Kassotis with an unknown object, an object which when used offensively against a person is likely to or actually does result in serious bodily injury by causing multiple traumatic injuries to the body in violation of that code, contrary to the laws of said state, the good order, peace, and dignity thereof. Am I the foreperson right now? I'm feeling like I'm the foreperson right now. Are we the mock jury? We're an international mock jury. We're going through it count by count. There's 2 boxes, guilty or not guilty, okay? Count 4. And the jurors aforesaid, that's us now. Okay, sorry. In the name and behalf of the citizens of Georgia, further charged and accused Nicholas James Kassotis, aka Nicholas Wannabe Stark, Jim McIntyre. Okay, they should have just on one of the counts just said Jim McIntyre. Anyway, with the offense of concealing the death of another, a felony, for that the said accused in the County of Liberty, the state of Georgia, on the 29th of November 2022, did unlawfully conceal the death of Mindi Mebane Kassotis, which hindered the discovery of whether or not said person was unlawfully killed by dismembering her, transporting her body, and hiding it in a wooded area in violation of that code, contrary to the laws of said state, the good order, peace, and dignity thereof. Check, he placed himself there. He said that Jim McIntyre, a made-up person. Jim McIntyre sent him there to meet up with another random guy, okay, at a random house that does not exist in the 13,000 square mile hunting area. This random house, a bit of a brick wall, yeah, very vague descriptions. And this guy, he was there to drop off the totes, which had their personal items in it. Nicholas Kassotis, he says that's what he did in that area. He was given GPS coordinates. He was told to switch off his phone. But he didn't realize that they would be able to track his car there later, even though he burnt his car. Yeah, so he was there. Mindy's dismembered remains were found there. And he was there on November 29th of 2022. I don't think he thought that they would discover her dismembered remains so quickly. Hunters and their dogs discovered the remains on December 2nd of 2022. Unfortunately, they could not identify Mindy for almost 6 months, 5 months. May 11th of 2022, she was finally identified. And as we know, in between, a brilliant sketch artist, a GBI forensic sketch artist, Kelly Lawson, made a sketch of, what they thought the victim looked like, just to generate tips and leads and see if anyone knew. They looked at dental records, they looked at DNA or anything they could find, and they couldn't, so they got the help of the FBI, not Jim McIntyre from FBI, no, he doesn't exist. The actual FBI, to look at genetic genealogy, track down her mother Betsy, found Betsy, did a buccal swab, and confirmed, holy crap, those are the remains of Mindi Mebane Kassotis. And then they went to the Airbnb where Mindy had last lived, and they found blood evidence in the house, including her blood on the futon, which the defense argues is not enough to prove anything. Sure, but it's her blood on a futon. And the rug is missing, replaced. And Nicholas's stories don't make any sense. So, count 5. We're deliberating. Count 4. We all comfortable with that? Sarah Grubbs, thank you for being a member for 4 months. You said the knife couldn't be identified as the weapon that caused the stab wounds. Unfortunately not, because they said abdominal injury, so I don't know what the heck was going on there. But no, it couldn't. One of the knives couldn't be excluded, but also couldn't be included. So yeah, that is one of the circumstantial evidence factors. So count 5 says, and look, yeah, it says Tracy Sands and prosecutor, GBI Special Agent Tracy Sands. It says count 5 and the jurors aforesaid in the name and behalf of the citizens of Georgia. Further charge and accuse Nicholas James Kassotis, aka Nicholas Stark, with the offense of possession of a knife during the commission of a felony. During the commission of a felony for that the said accused in the County of Liberty and State of Georgia on the 29th of November 2022 did unlawfully have on his person a knife having a blade of 3 inches in length during the commission of the crime of concealing of death of another. A felony, a crime involving the person of Mindi Mebane Kassotis in violation of that code, contrary to the laws of said state, the good order, peace, and dignity thereof. Plants and Pixel said, I think the jury will want to look over all the metadata, which may take some time. I would want to read it all. Yeah, right? I think if they take a while, it's also because there's lots to look at, including all that metadata. Can you imagine? So to count 5, possession of a knife during the commission of a felony, that felony they clarify would be concealing the death of another. I submit to you. Okay. That Milwaukee knife was found there at the Portal Hunting Club, where the totes were found, which he said was a gray and black tote. Now he says they're not my tote. They're not the same ones, and that's not the ones I dropped off. Yeah, they are. Yeah, they are. and they had Mindy's blood in them. So there's the knife under his arm. Okay, if you didn't see that during the trial, there it is. He's at Home Depot on the same day that his car was spotted out there. The same day he places himself in the area where Mindy's remains were found. And he was out there for 2 hours. Loba Volcano said, best mock jurors ever. Right, thank you so much for your sticker. Okay, so count 6 is possession of tools for the commission of a crime, a felony, for that the said accused in the County of Liberty in the state of Georgia on the 29th day of November 2022 did unlawfully have in his possession an insulation knife to fight mosquitoes. Oh no, they didn't say that? Oh, I thought that's what he said. Okay, an insulation knife, a device used in the commission of removal of body parts from the scene of death or dismemberment with the intent to make use of said tool in the commission of said crime in violation. That one's going to be a debate, because was it a decoy? Did he just put that out there, or did he actually use that? And is that why he used a cleaning wipe on it after? Did he clean the knife afterwards? I don't know. Count 7 is possession of tools for the commission of the crime. Now you can see count 7, 8, 9, and 10 are the same. It says that on the 28th day of November did unlawfully have in his possession a deer processing kit, a device used in the commission of removal of body parts from the scene of death or dismemberment. And it says with intent to make use of said tool in the commission of said crime in violation of that code, right? So it's just, I just want to quickly check. Okay, so this one is for the, count 7 is for the deer processing kit. Count 8 is actually says did unlawfully have in his possession on the 29th day of November of 2022, the day he was out there, possession of rubberized tubs, devices used in the commission of the removal of body parts from the scene of death or dismemberment. Oh, yeah, check. Mindy's blood was in it. So, yeah, and the totes were out there, and it matched the colors that he said, which, as the state said in the closing arguments, wow, what an unlucky guy. I mean, he's either the unluckiest guy in the world or a killer, because he knew the colors of the totes that would be found out there, even though he actually had no knowledge of the crime, supposedly, right? He's innocent. Yeah, they were found out there with Mindy's blood in it. So count 8. Count 9 is also possession of tools for the commission of a crime. And it says, did unlawfully have in his possession a Ford Explorer, a device used in the commission of removal of body parts from the scene of death or dismemberment, with intent to make use of said tool in the commission of said crime in violation of that code. Well, yeah, he was there, spotted on surveillance, right? We saw the surveillance video. We've also got, let me show you this image again. Hold on. Not the burnt car image. We do have that as well. Let me just see if I can find this other image. Actually, this one should be good. There he is. There he is in the area where Mindy's dismembered remains were found. The only person who had access to her that weekend, as the state says, while her parents were away for Thanksgiving. There he is. And he says he's there, but, you know, meeting some random person at a random house. Okay, so count 10 is also possession of tools for the commission of a crime, and this one says that unlawfully have in his possession a shovel, a device used in the commission of removal of body parts from the scene of death or dismemberment, with the intent to make use of said tool in the commission of said crime in violation of that code. Now that, they say he used the shovel to bury her head, and they say it because the roots of a tree under which her head, this is like, can you imagine the sentences I'm saying? It's a horrible dismemberment case, murder and dismemberment. So they first found her torso, and then a leg, and then another leg, and then later her buried head. And they said where her head was buried, the roots of a tree had been severed by a shovel. And we know he bought a shovel on November 4th of 2022. So, yeah. I'm sure you remember all of that, right? Seeing the shovel and all of that. Let me just see if I can find a picture. I mean, also, let me just go back to the car. And then his car burst into flames magically on March 20th of 2023. Just out of nowhere. While he was going to close on a house with wife number 3. And then didn't ever close on that house. I mean, really? By the way, here's a close-up of the knife that he was saying he was using to, you know, fight off mosquitoes. That he says, that knife's not the one I bought that day. No way. That's not it. Okay? And the other one, where's the shovel picture? I have a screenshot of it somewhere here. Hold on. We know about the tubs. We've seen them as well. Damn. That, we've got the knife one. Sorry, okay. Oh, yeah, wait. Let me just see if I've got it downloaded. I've got so many images. So many images to go through here. We've got that one. Here's the shovel. Here we go. There it is. Bought on November 4th of 2022. Okay. And the state alleges he used this to bury Mindy's head. I don't think they ever found the shovel. They also didn't find the deer processing kit. They also didn't find the rug that he says he replaced. And he gives a reason for that. So that's interesting. Count 11. Did we read count 10? We did, right? We just read count 10. Yes. Shovel, yeah. Count 11. Removal of body parts from scene of death, a misdemeanor for that the said accused in the County of Liberty in the state of Georgia on the 29th of November of 2022 did unlawfully remove from the scene of death and dismemberment of Mindi Mebane Kassotis a head, a torso with arms, a right leg and a left leg, each item being a human body part in violation of that code. Count 12 is tampering with evidence, a misdemeanor for that the said accused in the County of Liberty in the state of Georgia on the 29th day of November of 2022 did knowingly alter, conceal, and disguise physical evidence, to wit, the body of Mindi Mebane Kassotis, a knife, rubberized tubs, and cleaning wipes, said evidence involving the prosecution of the offense of murder with intent to prevent and obstruct the apprehension and of prosecution of Nicholas James Kassotis by destroying biological evidence and concealing tools from the commission of the crime in violation of that code. Okay, so that is what we have there, right? Thank you so much to Grizzly Cat for obtaining all these documents for us so that I can read this to you. So now what we're going to do is, let me just, so the jury has been deliberating for almost half an hour. Let me just quickly refresh this feed for us. And we're going to teleport to, unless they come back now, we're going to teleport to the verdict watch feed, and we'll go live when there's a verdict. I do want to show you his story. So this is apparently the short story that he wrote. Okay, just wait 1 second. I just want to make it so I can just zoom in nicely for us. Thank you to everyone who sent me this horror story. Okay, so again, the jury is deliberating, yes? Just put my little logo over here. So this is the story that apparently Sony bought for $300,000. Like, guys, do we need to start writing Reddit stories? Yeah? I mean, okay, so, damn. Here we go. NM writes, and this was apparently his, I don't know what to call it, handle, his channel on Reddit. It says, horror story. Everyone has their own nightmare in law story, though I couldn't imagine how bad mine would be. As it turns out, the worst thing wasn't my mother-in-law poisoning me. The worst thing was why she did it. I met Craig on one of my rare vacations, and we had sort of a whirlwind relationship. We fell hard for each other and were married in a courthouse wedding within 2 months without ever meeting each other's families. Mine visited a few weeks later, and after the initial shock, really liked Craig. Now in this story, is the person writing the story male or female? Not that it matters, I just wonder. Because I've always said, is Jim a boyfriend? Was Jim McIntyre a secret boyfriend? I don't know. Anyway, so, okay. So then it says, while we got moved in together and figured out married life, I got to hear more about his parents, who lived near the rest of his extended family a few hours away, though we never saw them. My work schedule is rough. I work 6 to 7 days a week, and my off days are a blur of appointments and errands. I think in the 2 years before I met Craig, I only left the city once. I finally got a few days off, so we could head to visit his family about 6 months later. His whole family came over, and everyone seemed thrilled to meet me except for his mom, Betsy. Now, I'm not going to break the flow of the story except to say that guess what? His actual mother-in-law's name at the time, was Betsy. Mindy's mother's name is Betsy. It's really weird how he just inserts that here, but okay. Okay, fiction story. Back to the flow of the story. So I'll start that paragraph again. I finally got a few days off so we could head to visit his family about 6 months later. His whole family came over and everyone seemed thrilled to meet me except for his mom, Betsy. She was cold and distant and could sit there without saying a single word to me. It was creepy, but I kept trying to spark up a conversation. On our last day, he announced that we should take an afternoon hike up into the national park by their house on the national park their house sat on the edge of. Betsy made lunch and I was changing to go out when it hit me. Just waves of nausea. I wound up in the bathroom for hours that afternoon. I figured it was just a touch of something and thought nothing of it. We went back a few months later and again had a great time, except for Betsy. She wouldn't talk to me, though Craig brushed it off and said she was just getting to know me. He finally said we could rent jet skis the next day and explore a lake in the next town as a way to get out of the house and unwind, which made me feel better. I was so excited to tell everyone where we were going, but it wasn't to be. After eating, I got so sick I could barely walk for the next 2 days. At this point, I started to get suspicious. No one else was sick, and we all ate the same food. It seemed like Betsy had been up to something, but it wasn't until our next visit when a night in a romantic cottage another hour up the road was cancelled due to me getting sick that I was sure Betsy was poisoning me. Craig said I was insane. He said it must be an allergy to something that his mom used in her cooking, which actually made sense, though I never had time for an appointment to get it checked out. Still, I decided on the next trip that I'd make a big casserole and bring it with us. If I cooked the food and served it, nothing could be added. Well, I hadn't had 2 bites before I realized I had left the wine that I was drinking unattended while I was heating up the casserole, and my stomach was already doing flips. You know what happened next, and it was not pretty. I was so sure his mom was poisoning me, and I confronted Craig about it. I told him I wouldn't visit his family again if she was there. It was our first big fight, but he finally said that he wouldn't force me to visit, and we could figure out how best to deal with the situation. She had never been nice to me, so it wasn't a loss. The next time I got time off, we decided we'd head to that little cottage we had rented before and not been able to use. We were driving right past his family's place and it seemed rude not to stop, so we compromised and bought some pizzas. I even decided just not to drink anything unless it was water from the tap. We got in and threw pizza on our plates when one of his cousins arrived and everyone briefly left the food unattended. I realized my mistake almost immediately and decided to try an experiment. Craig and I both had 2 slices, so I just switched our plates while everyone was in the next room. Craig was so sick, I was really worried about him. The drive back to the city was awful. We had to pull off a lot, and he was a mess. We had been back home for 3 days before I broke down and told him I had switched the plates. I've never seen such anger before. The rage in his eyes is something I'll remember for the rest of my life. He shoved me into a wall and then came flying at me. He threw me over the couch, but I somehow managed to grab my keys and phone and ran out the door, not even wearing shoes. I got lucky with the elevator and made it to a friend's place safely, finally turning off my phone after I missed his 47th call. I had no idea what to do or when it would be safe to go home. It was the scariest time of my life. It was 2 days before I turned my phone back on, and when I heard the message from the police, I drove upstate immediately. Craig was dead. Betsy had shot him after he broke into her house and charged at her with a knife. I learned that Craig had been married once before, and his wife had died on a tragic hiking accident. Craig made a lot of money in the life insurance payout, and Betsy always suspected Craig had killed her and was nervous about letting him be alone with me, especially out in the remote area that he was so familiar with from his childhood. So she ensured that every time he planned an outing that I would be sick. It wasn't easy, but she didn't think I would believe her, as no one else had ever shared her suspicions about Craig. I found the life insurance policies he took out on me without my knowledge afterward, and refused to press charges against Betsy. She was only trying to protect me. I still visit her from time to time when I need to get out of the city. I love her cooking. Like what? Guys! Wow, there's some interesting little elements in that story, isn't it? Now let me go back to the sticker. I couldn't read the time. Mama of 3 said 1 to 2 hours getting a verdict, then 1 to 2 hours laughing and snarking about Nick or Jim. Wish we had him buying rug. Yes, so that he could not blame the parents and Rusty. That would have been so good if they had that as well. Thank you so much for your sticker. Like, I am not believing I just can't. There are like what looks like legal documents related to acquiring the story. There's articles like this as well. Jessica Knoll, courtesy of Sabrina Lantos, okay, it's exclusive. Sony Pictures, 3,000 Pictures has preemptively acquired film rights to I Think My Mother-in-Law is Trying to Kill Me, a psychological thriller based on a Reddit short story by Nick Murfox. I do not believe that anyone paid him $300,000 for that crap. If so, I think every single one of us needs to immediately start writing stories on Reddit, okay? Because, wow, if he can get $300,000 for that, man, we need to start getting our pens out. It's just a short story as well. I mean, that didn't take long to read. Stefan said, I want to see the Sony contract. Until then, I don't believe it. I do not believe it at all. I think the money that he used to buy his car, cash, was Cameron's money, his friend Cameron's money. And any other money that he survived on was Cameron's money, because he took $198,000 from Cameron. So I do not believe, I just don't. After reading the story, I first thought, oh, okay, wow, damn, he did well as a writer, hey? Sure. That story, if that's the story, there's just no way, right? Do you believe it? Let's see what you say. Well, yeah, Taylor TJ said, I mean, $300K for Sony is chump change. Oh, geez, that's what I'm saying. Let's start writing. Everybody, yeah, so Bill Masonaki says, I need to get my crayons out. Me too. It's time to get our crayons out, Grizzlies. We need to start writing because, damn, Sony, hi. We can write short stories as well, and better ones than that. That plot sucked. I mean, really? Betsy is going to kill her own son because no one believes her that he is a killer? Interesting. Very interesting. Okay. Albert said 400,000. Yeah, that's what it was worth. Yeah, he said, I don't believe, he said 300K was he said the 400,000, that extra 100 included, you know, paying managers, producers, all other things. But he got 300,000 apparently. You said, I don't believe it either. I know little about optioning fiction. No way. Too much for too little. And Stefan said, nobody pays 300K for a short story anyway. So can they please add some more charges, you know, onto his docket there? Perjury for one. How about that? I mean, this guy can lie on the stand just like that. Sure. Kate says, my middle schoolers write better than that. Right? And if he got 300,000, they better start submitting their stories to Reddit as well. Samantha said, that story is crap. A la poubelle. That story is so a la poubelle, which in French means trash. So yeah, that is what I had to share with you today. What we're going to do now is teleport, redirect. If your autoplay, you know, there's a little button at the bottom of this YouTube video that you're watching, autoplay, you can toggle it on or off. If you do not have it on, you will not get automatically redirected to the next stream. So you have to click on the link when I post it in the chat here. Okay, so go there. It's the safest option. If I were you, I would just click on the link and go there and start saying hi over there. But if you want to wait here, wait for the outro to play and you should be redirected to the Verdict Watch stream, which will then become the Verdict stream. When a verdict is in, we'll be there live. I will be absolutely, as always, monitoring the court feed. The mods always monitor, the Grizzlies monitor. Email me if you see a verdict coming in, if you know anything, right? Please do. Joanne Kimball says, bless sweet Mindy for all she had to endure even before he unalived her. Prayers and love to all her family and friends. Thank you so much, Joanne Kimball. I really hope there will be justice. I'm confident there will be for Mindy. I can't imagine what she endured. I mean, he's just exhausting just watching him in this trial, right? Gerda says, hopefully 25 is our lucky number today. I think it could be, Gerda. Happy Grizzlyversary to you. All right, everyone. Are we now ready to go to our next stream? Wait. Yeah, I'm just checking. I thought I heard something in the courtroom. Wait, hold on. No, they've been deliberating for about, 42 minutes or so. So here we go. I'll put a poll up there as well. Okay, let's see. 43% still think 2 to 4 hours. So let's see. Let's see. In the next poll, we're going to vote what you think the verdict will be. Here we go, everyone.